Would you ask Mr. Hyet to come back in, please?
Thank you. Take my jacket off if I
Oh,
may.
do, yes, if you'd like to, Mr. Hyet.
Thank you.
All right, yes.
Yeah, Mr. Chairman, Mr. Hyet, we were on your report at 28, page 81, and looking at figure 3.42. Could we pan out, please, from the diagram and look at the text at the top of the page, where you say this? You say, where the horizontal cavity barrier interfaces with the vertical channel support of the cladding, a seal will be required to prevent any bypass of the barrier via the gaps between the cladding cassette and the channel, which is inherent in the channel and cassette system to provide buildability tolerances. The internal dimension of the spandrel cassettes is greater than the length of the vertical supporting rails to enable installation, and therefore gaps are inevitable. These must be sealed. The drawings below illustrate this condition. They can be read with the physical model provided for this condition. Now, your solution, I think, to the concern or problem that you've identified is to place a seal in those gaps, isn't it?
Correct.
And if we look at figure 3.44 on page 82 of this report, the next page over, we can see here the seals highlighted in green. Am I right?
Correct, yes.
So is it your proposal here to place intumescent strips bonded and mechanically fixed to the vertical channel? That's your solution, I think, there.
The exact way of dealing with fixing them, I think, would be the matter of some discussion, but one way would be to fix them onto the the outside sides of the channel, yes.
And is the idea that these would expand as cavity barriers would expand in the event of a fire filling that gap?
Correct.
Do you think that that approach would resolve this problem, namely the problem of the gap within the U-shaped rail we saw, which is caused as a result of needing to cut the cavity barriers around the cladding rail?
I believe it would. Could we go back to the previous drawing?
Yes, if that's on page 81. We can go to page 81, I think, which is the previous drawing. Is that figure 3.42?
Yes.
Right.
Why I wanted to show that drawing is that there is a discussion to be had about where is the outside of the building. If we follow the, you can see the note aluminium rain screen cladding, and there's a black dot that shows the outside face of the aluminium, but that returns into the channel and stops. It sits across the toggle. There is another aluminium cladding panel coming in as well. The tray is coming in there. So the outside of the building is the outside, the bottom horizontal line, but then it returns into the channel. And I think that the outside of the building actually goes right into the channel face, the inside part of the channel.
When you say the outside of the building, you actually mean the exterior face of the inturn or upturn of the aluminium cladding?
I mean the external face of the building returns with the tray, for want of a better term, into the channel. And it is essential that the horizontal cavity barrier closes that gap. It's a very difficult piece to gather in 3 dimensions. It'll be challenging. It's challenging for architects to get this. It'll be challenging for everybody else. But if you don't have that sealed, fire underneath the cavity barrier can break into the channel and then up inside the channel and back into the next concealed space. That's the space that forms the cavity above the cavity barrier. Is that clear? And this is what that is intended to address.
But it is to me. So long as my question was clear to you, I think that was what matters. And I think you've answered it. My question was, just to repeat it, if I can go back to it, whether this approach would solve the problem, namely the gap within the U-shaped rail, which
I think
the cavity barriers around the cladding rail.
what is shown pink would have to go the entire height of the tray. So the return edge of the tray would have to have that seal all the way up it, so that at no point can any fire that's got into the part of the channel where the toggle is, no fire in there could break back out around the edge of the channel and into the cavity above. So that would have to go the whole way up.
Can we then go back to page 81? I'm sorry, page 82.
Yes.
And look at figure 3.44.
Yes.
If you look at that there, you can see, as I pointed out to you, the green square
Yes.
with the arrow pointing to intumescent strip bonded and mechanically fixed to vertical channel. Do you see that?
Yes.
How would those seals or intumescent strips be bonded to the rail?
Well, they can be glued to rail, fixed in that fashion, because they've just got to stay there. Once there's a fire, they would expand, and the virtue of having expanded, they would fill the gap and stay there. So they've just got to remain in the non-fire condition.
Would another solution, which could be adopted, be the use of mineral wool within those gaps, compressible mineral wool?
Yes, provided that it could be firmly adhered and retained. But the difficulty with that is that in order for the mineral wool to fill the gap between the channel and the and can I call it the lip? Would everybody understand if I say that? In order for it to fill that gap, it would have to. It would be much thicker, and pushing the cassettes on would be a difficult thing, because the mineral wool would be in danger of being snagged and pushed out of position. It's better to have something thinner, like an intumescent strip, which will then expand.
Now, you can see on this diagram, and as we can on the previous one, let's start with this one at 3.44, that still leaves a gap in the vertical channel at the very back of the rail, doesn't it?
Yes, and everybody's got the idea, have they, that this is a worm's eye view. You're looking up at it from underneath.
Yes, absolutely. So this is the opposite of a plan, I think.
Well, it's a sort of axonometric. We do two types of these drawings. One is looking down, because it's a perspective. The other is looking up from underneath.
Yes.
This is actually looking up from underneath. It requires almost quite a bit of imagination to do this.
Right, well, I think I've got enough imagination to be able to pose the question, and that is, looking up at it from my position as a worm, there is a white area still to the, as it were, southeast of the green oblong.
If I may say so, well done, that is correct.
Right.
Yes.
It's probably easier to see on figure 3.43, 3.42, I'm so sorry, on the page 81, if we go to that, because I can ask the question better, I think, by reference to that.
Yes, so it is.
Yes, you can still see the white part at the top of the of the U, which you've identified as vertical cladding channel. That gap remains, doesn't it, notwithstanding your proposal?
That's correct.
Why would it be acceptable to leave that gap in unfilled?
Because I made the point a few moments ago about the distinction of what is the outside and the inside of the building. I think the outside of the building, the outside of the cladding, is the slot between the two edges of the cassette as it goes into the channel. I think that's arguably still outside the building. But either way, the pink there would go from top to bottom, and therefore it would seal the inside of the cavity inside the rain shield. It would seal the cavity inside the rain shield above and below the cavity barrier from that vertical space within the channel. So effectively, the inside would have been sealed from the outside.
Yes, I see.
It's a challenging thing to grasp, I'm afraid.
No, you've explained it, I think, very clearly, and if you haven't, no doubt I shall be asked to clarify it further with you. But just looking at that and thinking about it, that's a bespoke piece, isn't it? The pink.
Yes, yes.
And is that something that could be engineered on site, or would that need to be considered carefully by the architect long before this got anywhere?
I think it would want to be thought. Well, I'm going to qualify that if I may in a moment. But I think ideally it should be thought about early, because the overall arrangement has to be signed off as workable, and unless you can deal with this, then the problem may not be solvable. So I would wish to see it solved early. However, I'd like to qualify that if I may. Is that okay?
Yes.
I've been given the privilege of looking at this with all the information that is now available. At the time that this work was done, 2012, 2013, take it right through to 2016, there would not have been the level of focus on an issue like this. Mr. Lamb, I think, is quite correct. I haven't done any kind of audit of the buildings across the country, but where buildings have got cassette arrangements like this, then I think those are likely, I only say likely, to show this kind of problem unresolved. This is an issue I think that the entire industry is going to have to look at very seriously. Rain screen systems need to be considered carefully in terms of the protection of the cavity, and Dr. Lane talks about the integrity of the cavity barriers. That's one thing. The second issue is even if the cladding line stays where it should, we must deal with gaps around it. And this has had a level of scrutiny that I don't think would have been routinely applied by design teams at the time.
Looking at the distinction, if there is a distinction, between the work to be done by Studio E as the reasonably prudent architect and the work to be done by Harley as the reasonably prudent and skilled cladding subcontractor, is the design and specification of this detail here and your solution to the filling of this gap one which would be examined and arrived at by Studio E or by Harley, looking at it from the point of view of the reasonably competent architect?
I think it tips into the territory of the specialist subcontractor.
Right. Now, can we move on to look at the sill?
I beg your pardon, if I may. I think that in the future, architects would look at a thing like this and want to know how it is solved, but the solving of it tips to the territory of the subcontractor.
Right. And if it was solved, it having tipped into the subcontractor's territory, as you put it, would it nonetheless be something that the reasonably prudent architect would want to know about and satisfy themselves about once the specialist cladding subcontractor had arrived at this solution?
Yes, except for that would be the architect in the role of coordinating the team, and the important team member here is the specialist fire consultant. And so I think that they would want to make sure that the architect would want to make sure that all the brains that are going to be applied to it from the consultant team side have been satisfied.
Right. So do I take it from this exchange that the examination and specification of this solution is not something that you would expect the reasonably prudent architect to come up with and examine at stage E or F1?
Then I don't think so. Right. Now I do.
I see. Can we then turn to the sill level? Can I go, please, to page 73 of this report? And let's look together at figure 3.35. This is a typical detail, number 2, sill detail. And again, I think, am I right, this shows the bespoke piece at the sill, third down on the left.
This is correct.
And it says, bespoke sill piece by manufacturer of vertical cavity barriers to fully fill residual cavity at windowsill. Alternatively, if not available, residual cavity filled with material, wool bat held under compression. Now, again, same questions, and I'm sorry about that, but I need to ask them again in relation to this detail. Breather membrane, we can see there's a breather membrane you've added 2 items down from what I've just read.
Yes.
To run between the cladding bracket and the sill cassette and dressed
Yes.
over the horizontal cavity barrier. Right, now, would the breather membrane there require a gap between the sill piece and the cladding?
No, my answer is, you may wish me to go through every point again, but my answer is it's the same condition as the jumb. The breather membrane allows moisture to pass out, but stops wet going in, and so moisture can pass out of the bespoke piece there, and then it would spread up under the inside face. It would pass up under the inside face of the cassette and out at the sill level.
So do we read your answers in relation to this detail here as the same
Yes.
as you
Yes.
gave us in relation
Yes.
to the earlier drawing
Correct,
and
sir.
diagram we looked at? Now, we can see, and it's a question that really hangs, but we can see here, and we can ask it off this diagram, that the new windows at Grenfell Tower were placed outside the plane of the original masonry line, weren't they?
Plane is the word I should have used earlier. That's absolutely the right word, yes.
But was it necessary to do that? Was it necessary to have the windows in that location?
We call it the thermal line. The insulation outside the building needed to be continuous through to the windows. If that wasn't achieved, there'd be what we call a cold bridge, a gap. So there's all sorts of problems with that. Apart from the loss of insulation, there's condensation, all sorts of problems. You may remember, and perhaps I could refer to it, when I was explaining the model, I believe I said that if the windows had been left in their original position, the insulation would have had to have been brought down the spandrel panel. I'm taking the section through the building, down the spandrel panel over the window, and then it would have had to have turned and gone under the concrete slab until it reached the window. That would have been a depth of something like that. Likewise with the sill, it would have had to have come up and then crossed to meet the window frame. That would have reduced the depth of the windows. It would have had a major, I won't say adverse because that's subjective, but it would have had a major impact on the appearance of the building. It would have reduced the view from inside. At the jams, the same thing would have had to have happened. So I think it would have been difficult to deal with, and therefore I believe most, if not every architect, would conclude that to overclad the building, the windows would move out.
Thank you. I now want to turn to a completely different topic, which is building control.
Sorry, to overclad the building with insulation on the outside, then the windows go out.
Yes, I understand. As I say, I just want to ask you now some general questions on the subject of the involvement of the building control body, if I may. Can I take you to your supplemental report, please? PHYS 605, at page 57. And let's look together at paragraph 6.8.3. And you say there that, and you quote from the RIBA Legal Handbook 2013, second edition, and you say that, and quote, the architect may produce design documentation that is approved by the Building Control Service, but the architect must still comply with the requirements of the building regulations themselves and not rely solely on this approval. Paragraph 7.5.1 at page 185. And you give the reference INQ 3013967. Can we take it that it's, in your view, not reasonable for an architect to rely on building control as the only check on whether a design complies with the building regulations?
That is my view.
Yes, and that a reasonably prudent, reasonably competent architect must check that for himself, whatever the building control body decides to do.
That is correct.
Yes. In relation to the full plans application, you say in your report that it's accepted practice that a full plans application should be submitted with a set of general arrangement drawings and typical construction details. I can show you that if you want.
No, I remember it.
Just for reference purposes, it's paragraph 5.1.8 on page 5. But you remember that's what you say. In your experience, would general arrangement drawings include basic details such as the type of cladding proposed?
The generic type, yes. Not necessarily the manufacturer, but the generic type.
When you say generic type, could you be a bit more specific?
ACM, zinc, terracotta, whatever it's going to be.
I see. Would general arrangement drawings typically include the insulation proposed?
Same answer, generically, yes.
So what would that be in the case of FR 5000 or RS 5000?
Well, it could be mineral wool if it was not going to be that. Alternatively, I suppose it might be PIR, or it might just simply specify the name.
Right. What about the cavity barrier strategy? Would general arrangement drawings include basic details about the cavity barrier strategy?
Well, it's a design and build contract. I know there were delays. This one went slower than was anticipated, but it's getting pretty late. No, my view is that the cavity barrier strategy should have been sorted out before they ever went out to tender anyway. So having got it sorted out then, that would be information available to submit with a general, with a full plans application.
So the answer is yes.
The answer is yes, yes.
At the full plans stage, would you also expect a clear statement about which route to compliance?
Yes,
with?
Absolutely. I'm sorry, I should have waited for you.
Yes, it's route to compliance with 12.6 to 12.9 of ADB,
Yes.
and the answer is yes. And would you expect a clear statement from the designer, and for the present purposes, I mean Studio E, that the proposals complied with the building regulations? Would you expect a clear statement from the architect in accompaniment with the general arrangement drawings?
I don't remember ever giving such an assurance. I think it's implicit.
Right. Conversely, would you expect them to flag up any issues where they either knew or thought that there was any doubt about whether what they were proposing was compliant with?
Not with a full plans application, because any uncertainty should have been resolved beforehand. There may be things to be resolved later that haven't been shown, but the full plans application, insofar as it gave information, should be compliant.
Can we go to your report, please, at PHYR 5030 at page 6? And I'd like to go to paragraph 5.1.22 there in the middle of the page. You're discussing the information to be forwarded with the full plans application there. And you say such a rolling process for the issuing of information requires very clear communication. In particular, the applicant should make it clear that such information is to be received as part of the initial full plans application, and all documents subsequently submitted should be clearly identified in that respect. In your view, did Studio E meet that requirement?
No.
Could you just briefly clarify why you say that, or explain why you say that?
Well, I can't remember exactly which documents I have seen, but I can't name them, but I've seen a large number of documents, a large number of communications, emails, etc., which were not explicit as to the purpose of the drawings that were attached to them. Apart from the fact that we've got all the problems with drawing numbers and that, we've got, I would prefer to see a situation where a full plans application is made. Drawings are listed on that application and their general arrangement. They're sufficient for the building control officer to understand the proposal and the building. Subsequent information is going to be submitted. Each time each package of subsequent information should state that it is part of that original application. It's not some parallel inquiry. It's a part of the application. Here is another piece of the application. It should list the drawings clearly. That wasn't done, and our job, certainly, the architect's job is to ensure that the building inspector has every assistance in discharging his or her duty. We have a complete picture of the building in our mind, and we should, if we haven't got all the information together at the beginning to submit in one application, then subsequent pieces of information should be clearly described, clearly stated in terms of where they fit into the whole, and related back to that full plans application, and that was not done.
Did Studio E's approach in general to the full plans application and the building control process meet the standard of the reasonably competent architect? And again, is that for the same reasons, or are there other reasons?
It's the same reasons. I think that what I've described encompasses the problem.
Well, let's just look over the page at pages 7 and 8 of your report, at paragraph 5.1.26, because I think we see there your reasons. This is under the heading Summary of Findings, and you say the picture that emerges through this review is one of general disorder, which I summarise as follows, and you've got them summarised there. A, the pre-application dialogue was not comprehensive. B, the full plans application was late. C, lack of coordination in terms of processing the application. D, over the page at 8, lack of precision around dates of information issue and receipt, and in terms of drawing numbers and revision references. Do those remain your key reasons why you are critical of Studio E in this respect?
They do, and I think it should have led to the rejection of the application.
Are there any other reasons, now that you've heard the evidence and seen the transcripts of from the witnesses, that you would add to that list?
Could I just go?
Yes, of course.
Ask to go back to the previous page?
We can just go back a page to page 7, please.
I think this is these general headings cover it.
Very well.
Yeah, I think it covers it.
Very well, thank you. Now, Mr. Crawford's evidence, and I'm summarising it, but his evidence was that he wasn't aware of Regulation 38 of the building regulations. Now, just to be fair to him and clear with you, I should show you what he said. It's day 11, page 123, please, at line 9. He was asked by me at line 9, were you aware of Regulation 38 of the building regulations at the time of the Grenfell Tower project? Answer, I don't think specifically. And then I took him to Regulation 38. And then at line 23, he said, I asked him, was that something you were familiar with at the time of your involvement in the project? Answer at line 25, not specifically, no. My question is, would you expect a reasonably competent architect to be aware of that provision in the building regulations?
Yes, and certainly if they even know it or in taking on this project, they're going to carry out their code review and they pick it up.
In your experience, at the time of the Grenfell Tower project, what was the general standard of awareness of Regulation 38 within the architecture?
On a building like this, it would have been known by a competent architect.
Thank you. Can I then turn to a different topic again, namely fire safety advice? And I want to ask you something about the fire safety strategy reports in general terms, and some questions about Ixover's appointment. Can we go first to Ms. Menzies' report at BMER 604, please, at page 97. And she says there at paragraph 305, a quarter of the way down that page, she says, the Ixover fire strategy, that's EXO 401106, made no reference to alterations to the external walls of the building. It set out that the changes were thought not to adversely affect external fire spread, but, quotes, this will be confirmed by an analysis in a future issue of this report, close quotes. It was / is not unusual for a B4, quotes, analysis, unquotes, of external fire spread to be submitted after a conditional decision has been issued. However, any decision should have requested submission of the details. Now, this would be the conditional rejection or approval of the full plans application. Do you agree with her opinion from an architect's perspective?
Yes, I don't have a problem with that, no.
Now, you say in your report, and just for the transcript, this is at 4.1.33 of your report at PHYR 5029 at page 12. You say, it is very important to note that the principal components, stroke products, stroke materials that make up the overcladding cannot be considered in isolation. Now, is a consequence of your view, which I've just quoted to you, that a full analysis of the facade system for the purposes of compliance with B4 of the building regulations depended on the person doing the analysis having full details of the final materials decided upon for installation?
Yeah, I think that follows, yes.
So that would include, and I'm inviting you to agree, the PIR insulation and the ACM panels with the PE core.
Yes.
Do you consider that a full analysis then couldn't be undertaken by Exova or any other fire safety engineer until the NBS specification had been finalised and provided in November 2013, or perhaps January 2014?
It could have been done in principle, but the finalisation of it would have been dependent on the finalisation of the fire safety report would have been dependent on the finalisation of the proposals.
When you say the finalisation of the proposals, do you mean the final decision to procure and install a particular product?
Yes.
So taking the ACM panels, PE panels, the decision to adopt those was made various times, but during a period between May and September 2014. Are you saying that during that period, and only during that period, Exova would have been able to do the full analysis that they've indicated they would do?
As the timeline becomes quite complicated here, I almost want to set the timeline out on the table, but there was information coming out of the design team in Exova's direction, the C and the D report, that gave plenty of information upon which they could get their teeth into and pass commentary, and should have, in my opinion, passed commentary as the design developed. That would have put right errors that were being made from the beginning. The final sign-off of that would have required them to have been given the drawings and specification of the proposal, following any value engineering and anything else that had been done to it. But they had certainly plenty to pick up along the way.
Would you consider, as an architect, that the pre-tender fire strategy reports, by which I mean the design note and the 3 issues of the outline fire safety strategy done by Exova between October 2012 and the 7th of November 2013, no longer reflected the proposals given the changes that were then made in terms of the material specified?
I've only looked at the fire report from the point of view of the overcladding. Dealt with many other issues, but I've looked at it from the point of view of the overcladding itself. With that said, could I ask you to give me the question again?
Well, I might try it differently. Given that in November 2013, which is in, and let it be assumed only a week or two after the last of the issues of the outline fire safety strategy.
And that's when they were going out to employers' requirement tender?
Yes.
Yes.
At that stage, we've seen the NBS specification, which contains FR5000 for the insulation and zinc for the rain screen, but with the set of alternatives we saw at H92 in the NBS specification. At that stage, would the reasonably prudent architect go back to Exova and ask them now to produce their report, their B4 analysis on the basis of those materials?
Yes, I think in coordinating their work, they would, preferably earlier than that, they would have, it didn't just all happen in the last moments. That employers' requirements document took a good few weeks to pull together. They would have been able to have asked Exova to check that as it was looking at that time. It's not a mad scramble on the eve before the issue. In the run-up to that, documents have been published. They should have asked them to check it and to comment.
Right. And then breaking that down further and moving forward further in time into 2014, after Ryden had been identified as the winning main contractor, do you think that, that a reasonably prudent or reasonably competent architect would have then gone back to Exova and asked them to produce the B4 analysis once the identification of the rain screen had been arrived at?
Absolutely.
Between May and September 2000.
Absolutely.
And the same question in relation to RS 5000 as of August 2014.
Yes, yes. I'm not quite clear in my mind how the switch from FR to RS was communicated to the architect.
Given the changes from the specification of the rain screen cladding material and the insulation in the NBS specification that then occurred during 2014 after Ryden had been appointed, do you consider that the reasonably competent architect ought to have advised Ryden that the pre-tender fire strategy reports no longer reflected the proposals and needed to be revisited?
Yes.
Thank you. Now, we know that, I say we know, it appears from the evidence, and take this as an assumption from me, that Ryden took the decision not to appoint Exova or any fire safety engineer post-novation, or at the very least, let me put it the other way around, no decision was taken to that effect. Is it correct that under its appointment with the TMO, Exova, an architect would have expected Exova to provide that advice?
Ryden did not take Exova on.
No.
Studio E know that there's outstanding, know or should have known that there's outstanding information. It's never been closed off. They should have either been making it very, very clear to Ryden that there was a need for a specialist consultant to be appointed by Ryden in the absence of Exova to complete that work, or they should have made it clear that they were going to have to pursue that through Exova under Exova's appointment to the TMO.
Now, sorry, can I just ask you this? We've now got to the stage where Studio E are the consultant to Ryden.
Yes.
Exova are still a consultant to the TMO. What status does the architect have to start requiring Exova to do work for the TMO?
I don't think the architect has any authority to. The architect is no longer the agent of the TMO and cannot therefore instruct work, particularly if it's going to cost money from another party. But the architect has a new client, which is Ryden.
I understand that the architect, in your view, should tell Ryden that there's work that remains to be done. I don't have any difficulty with that. It was just your next stage, that they should take it up with Exova, that I was questioning.
Yes, I'm perhaps being a little informal there. They should have satisfied themselves that it was being dealt with somewhere. And maybe they needed to say to Ryden, you please get in touch with the TMO and ensure that that Exova have the proper authority and instruction to answer questions that we have.
In the end, is it for the architect or for the design and build contractor to decide whether to obtain further information of that kind?
All of the design and build contractors that my firm, when I was with it, has had experience of, have, as I understand it, because I haven't been involved with them all, but they've insisted on having a specialist fire consultant appointed. If they did not do that, my colleagues would have recommended it very strongly to the design build contractor. So at that point, there would be a recommendation that this report has outstanding issues. It's come forward and it's got outstanding issues. They've got to be closed off.
Yeah. All right. Well, perhaps that's as far as we can take it. Yes, Mr.
It may be, and there are a few perhaps a few loose strands that I just want to pull on if I can. Now, we know from the appointment with TMO that Exova had that they were obliged to provide advice up to RIBA work stage F unless the appointment was terminated. Now, let's proceed on that, the basis that I'm correct about that. At the time of the tender, the design had reached work stage E, I think, or perhaps F1.
Yes.
If there was any work to do to take it firmly into stage F, is it your view that Ryden was entitled to rely on Exova fulfilling its outstanding obligations under its appointment to the TMO?
Is that one for Mr. Hyet?
Well, it is, because
Well, perhaps we should rephrase the question.
all right.
The-
From the
architect
prudent
expects
architect's
to have-
point of view, having been, as it were, novated now to Ryden, would that prudent architect be entitled to expect Exova to continue to fulfil its obligations under its appointment to the TMO and continue to provide advice up to the end of its retainer at stage F?
I think I can best answer that by saying this is a pretty unusual and unsatisfactory situation. Well, I don't know how unusual it is, actually. Again, I've never done an audit of that. But it's a pretty unsatisfactory situation. And I think that the architect, in terms of the safety of the project and responsibility for the project and to his new client, needs to make sure that this matter is dealt with. So perhaps the architect should speak to the contractor client and say, will you give me authority to go and speak to the TMO and make sure that we have an ongoing arrangement with Exova, informal as it might be, that allows us to get the information we need. But this needed to be closed out.
And when you say this needed to be closed out, what's the this?
The many times repeated two lines.
Yes. So the production or confirmation through an analysis in a future issue of this report.
Yes, which in themselves have a horrible ambiguity in the line anyway, but
Well,
we know what we're talking about, yes.
Right. In your experience and in these particular circumstances, again, from a prudent architect's point of view, would you expect a design and build contractor or a client in the position of TMO ordinarily ask the architect to make sure that the specialist fire safety engineer had the information necessary to be able to deliver the advice up to stage F?
That question is, after novation, the architect is
Yes.
now novated. The contractor, the design and build contractor, is offering himself as a design and build contractor, not just any contractor, a design and build contractor, with management skills. They're going to manage the ongoing process of design development. I think that they should have taken the driving seat here and ensured that a proper audit was done on the employer's requirements documentation to make sure that it was complete and that any gaps were identified and instructions were given to fill them. So I think that is my answer, yeah.
Yes. And just to tie up I think one remaining loose end on this. You may already have answered this question, so forgive me, Mr. Hyet. But in your opinion, ought the reasonably competent architect in this situation to have made it clear to the design and build contractor that the work of the specialist fire consultant hadn't been completed under that fire consultant's pre-novation appointment?
Yes, that is correct. Why I hesitated is yes, but not solely the architect. There's a number of parties here.
Yes.
But yes, the architect as well.
Yes. In your experience, would an architect novated to the design and build contractor ever insist on the appointment of a specialist fire safety consultant on a project such as this?
If I said that earlier in my evidence that some architects would be very much more comfortable doing a building like this because they'd done many of them. If they felt very comfortable, no. But you asked me earlier on, should an architect assess their own abilities? I think this architect should have considered its own experience and abilities. This was the first time for a building of this type, and at one level it's pretty complicated. They could have given the strongest recommendation. If the contractor was not willing to accept that recommendation, then it was within their powers to say, well, we cannot continue on that basis.
Yes, I'm really just asking.
That would have been a wise thing to do.
Yes, it may have been the wise thing to do. What I'm really after is your opinion as an expert, hypothetical, reasonably competent architect. Would that person, novated to the D&B contractor, as we've seen here, insist on or advise in strong terms that its client, the D&B contractor, should appoint or take over the appointment of the specialist fire safety consultant on a project such as this? Appoint
another or take that one over. That recommendation should have been clear. They should have said, we need that help to do this properly.
And if the architect didn't do that, in your opinion, would they be falling short of the standards expected of a reasonably...
If they weren't absolutely confident about their own ability alone, then they were falling short. I'm sorry I've qualified it in that way because some architects would have that competence, but I think these architects should have appreciated that they didn't, that it's outstanding, it needs to be dealt with, and they should have given the strongest recommendation.
And same question again, where the circumstances become that there is a material change in the materials specified with the tender documentation.
Yes.
Can we now turn to your supplemental report, please, at page 5? PHYS 605, at page 5. You can see paragraph 3.1.6.5 on that page. And you say there, if, as I infer from its statement, Exova is suggesting that the cladding system includes the entirety of the overcladding work that was carried out under the 2012 to 16 works, which essentially comprised the thermal insulation, rain screen cladding, cavity barrier arrangements, windows, together with their infill panels and the internal window head, jamb and sill interfaces, it is misleading for Exova to claim, as it does at paragraph 5.1, that its work preceded the critical decisions in relation to the cladding system, and as it does at paragraph 6.1a3, that every critical decision in relation to the cladding system was taken after that date. Do you take issue with that? And I think you also go on to say in the next paragraph, on the contrary, two fundamental decisions relating to the elements of the overcladding work, one relating to a choice of PIR product for thermal insulation, and the other relating to the extent and disposition of the cavity barriers, were made prior to November 2013. Now, it's right, I think, that Celotex FR5000 was specified in H92 of the NBS specification, as we've seen. Studio E didn't provide Exova with a draft copy of the NBS specification. In those circumstances, Mr. Hyet, would you expect the reasonably competent architect to do so?
Yes, yeah.
Would you expect the reasonably competent architect to ask the specialist fire safety consultant expressly for advice in respect of the materials to be specified within the NBS specification?
Yes, the architect needs to be comfortable that overcladding is compliant.
And I think you told us earlier
Yes.
that you would also expect that view to be sought from the specialist fire
Yes.
consultant in relation to the cavity barrier strategy
Yes.
at that stage.
Yes.
Yes. Or you would expect the architect to read off other advice provided by the specialist fire safety consultant when compiling the NBS. I think you'd make that point.
Correct, yes.
Now, in September 2014, and indeed March 2015, Studio E did seek some advice from Exova in respect of the cavity barrier placement or location, and we've seen some of that before. Is your view that Studio E ought, as a reasonably competent architect, to have sought such advice earlier in the design process?
Yes, absolutely.
And indeed in respect of the cavity barrier strategy in its entirety?
Yes.
You clarified that before. And on that, do you think that Studio E ought, acting as a reasonably competent architect, to have involved Exova in those decisions?
Yes, they were. We're now pre-novation. The architect is the lead consultant responsible for.
No, we're post-novation.
Oh, sorry, I beg your pardon.
September 2014, March 2015 is post-novation.
Right. So, could you ask the question again?
Yes. Should Studio E, as a competent architect, a reasonably competent architect, have sought the advice they did in September 2014 and March 2015 at a much earlier stage, namely pre-tender?
Yes, absolutely.
Yes, I see.
I'm sorry, that is correct.
Yes, yes. Can I then turn to the topic of value engineering? And I want to ask you some brief questions on that subject. Can I ask you to look at PHYR 5027, please, at page 4? And you say that paragraph 2.1.8, in relation to Dame Judith Hackett and her report, you say, I believe that Dame Judith Hackett is correct in suggesting that the culture within the UK construction industry has been orientated with an emphasis towards cost and value engineering at the detriment of safety. Of particular relevance to the circumstances of Grenfell is the following quote that alludes to a tendency to transfer of responsibility for issues relating to safety ever further downstream. And then you quote from the final report. Do you agree that this culture does not excuse the reasonably competent architect in the UK at the time of the Grenfell Tower project from considering the safety of the proposed changes brought about by a value engineering process?
I do.
And that it would be so in relation to whether the process related to drawings or to materials or products specified?
Yes, correct.
Do you believe that the phrase value engineering had, by 2012, become a euphemism for cost cutting?
I do.
Do you agree that in a true value engineering process, the functionality of design would either be preserved for less cost or improved for the same cost as originally proposed?
I'm sorry, Mr. Millett. I've got to be very careful with answers like the one I just gave. Could you restate the question about euphemism?
Yes. Do you believe that the phrase value engineering had, by 2012, become a euphemism for cost cutting?
Difficult to make a generalization. Many design build contractors are highly competent and highly responsible and will interrogate a design with great effect and find cheaper but not worse. Less expensive is a better term, less expensive ways of doing something. That is value engineering, that's very useful. And I don't want to give an answer that would dismiss the good quality work of many good design build contractors.
Relating that back to your opinions about the Hackett report that I've shown you at paragraph 2.1.8 in your report, do you detect, or looking back on it, that in the period 2012 to 2016, value engineering had become part of the process or part of the exercise whereby a transfer of responsibilities for issues relating to safety went ever further downstream, as you put it?
I'm not sure I can link the two of those together. Frantic cost-cutting exercises are common in the building industry, and that is not a good thing. In that process, many decisions that should be taken earlier are left till later, and a very convenient way of dealing with responsibility is effectively to package it and pass it elsewhere. And I think that there has been a tendency to do that. And the end result of that in this situation is that people who have not had proper training to make decisions that they are making, often against desperate constraints of time and isolated from those that could advise, are making decisions about design and work, and we see it with faulty specification and faulty design drawings. That's a long answer, I'm afraid, but our industry is not in good shape in this respect in many of its constituent parts.
Leaving aside the question of whether the words value engineering had become a euphemism for cost cutting, do you detect in your work, looking back on the period, that the principles behind value engineering had become compromised, such that people then approached the concept of value engineering without adequately taking into account the importance of maintaining functionality and performance?
I have a sense that that's taken place. I don't offer a holier-than-thou response, but I have a sense that that has been a pressure within the industry. But I'm also, I don't have any direct experience of that. Those that I have worked with have taken the work immensely responsibly. So value engineer, I've never been under pressure to compromise safety or anything like that by contractors who are bringing great pressure to bear in terms of achieving greater cost efficiency. But I have a sense that that is prevalent in the wider industry. But it is only a sense.
Do you consider that the role of the reasonably competent architect in a value engineering process, properly so called and properly addressed, would be to advise its client on the suitability of the proposed substitutions by way of materials or products?
Absolutely.
Can I then turn to the final topic, which is designing for disability? When acting as a lead consultant or lead designer from the outset of a project with responsibility for design coordination, is it an architect's role either itself to provide or at least to identify the need for specialist advice on access or functionality for those with restricted mobility and other disabilities?
I believe that is the case.
Would it be incumbent on the reasonably competent architect as a lead designer to make sure that the correct advice was given to the client as to the requirements in architectural terms for people with such disabilities?
Well, the correct advice has to be obtained by the design team, and the design must reflect that advice. Yes.
Can I ask you then to turn to SEA 406551, please? This is an email from Adrian Jess of Studio E on the 12th of November 2012 to Andrew McQuat of Max Fordham, and he's answering the question posed by Andrew McQuat the day before. Hi Adrian, are there going to be any new refuge areas in lobbies? If there are, I think I will need to provide a refuge telephone system to provide two-way voice communication between the fire refuge and reception. It would be good to know if you covered this with building control. And Mr. Jess's response is no refuges. Mass evacuation is not part of the existing fire strategy, and we are following their lead. Generally, people stay in their flat unless their flat is on fire. I assume the intention is for vulnerable people to refuge in other flats on the same floor before being evacuated by the fire brigade. Do you consider it reasonable for an architect to take the view that they would simply follow the client's lead as to what was required rather than giving advice about what was required in this respect?
Where is Adrian Jess from, sorry?
He's Studio E.
Right. I'm just going to read it again with that in my mind. At the time, I think Mr. Jess's answer seems to me to be a reasonable answer.
Now, I put it to you on the basis that he was proposing to follow the client's lead. It is, of course, possible that what he means is following building control's lead, given that it's building control that's referred to in the third sentence of Mr. McWatt's email. That being so, do you think it would be reasonable for an architect to take the view that they would simply follow building control's lead, whatever that was in this respect, rather than actually thinking about it and giving advice about what was required to its client?
At that time, I think we all had a great deal of confidence in the compartmentation, stay put strategy, and I think that the response is reasonable. Today, it would be very different.
Well, would it? I understand that, and thank you. But would we just press you a little bit more? Would you think, or would you agree with me, that the reasonably competent architect shouldn't make assumptions about what the fire strategy for people with disabilities was, but should consult with the fire engineer, if there was one, as there was, as to the nature of that strategy?
Or the disability consultant.
So yes, or the disability consultant. Is that your answer? Because if so, it answers my next question.
It's very difficult. Ideally, yes. I'm not sure how heavily I would criticise them for not, but ideally, yes.
And would a reasonably competent architect consult a disability design consultant instead of just proceeding on an assumption?
I think it's the same answer.
Yes, thank you.
Well, now, would he be expected to go himself to a disability consultant, or I suppose this is before there's any innovation, so he is the principal designer, isn't he?
Yes.
So I think the question is whether you think that Studio E fell below the standard reasonably to be expected by not making the running going to a disability consultant.
Well, if I could just preface the answer I'll give. On projects that I've recently been involved with, we go straight to a disability consultant because of the complex nature of that building type. I'm now talking about the Optus Stadium. This building was already in operation. Mm-hmm. It was managed by a professional client organisation. The architect is is part of a team that are making various changes to the building. I don't think that those changes in the upper parts of the building were going to be significant to the organisation of escape and the layout. They were in the lower part of the building. It was important, therefore, to have an expert fire consultant in for that lower area. I'm not sure that an architect would necessarily have required a disability consultant to step into a project of this kind because it was already occupied, already established in its operation.
Thank you.
Yes, thank you. Mr. Hyet, I've come to the end of my prepared questions, you'll be glad to hear. And in any event, Mr. Chairman, this is probably the right time for a break. Yep. If we take a break now, I can then sweep up any further questions that I may have or others outside this room may have.
Yes, that would be very convenient. Well, Mr. Hyet, we'll have a break now. We'll come back at 3:30
right,
and see if there are any more questions or not. And in the meantime, please, as before, please don't talk to anyone about your evidence while you're out.
Thank you.
All right, you'd like to go with the usher, please. On for 3 then, please. Thank you. Would you ask Mr. Hyet to come back in, please? Thank you. Right, Mr. Hyet, we'll see if there are any more questions for you. Mr. Millett?
Mr. Chairman, yes, just one or two topics. First, Mr. Hyet, have you ever applied the linear route to compliance with sections 12.6 to 12.9 of approved document B in your practice?
Yes, yep,
You have.
yes.
Have you ever personally prepared a specification for a rain screen cladding system in your practice?
Yes. Not me, but yes.
You say not me, but yes. Does that mean in your practice?
I have not, but the practice has.
Right. Were you involved yourself in that?
No, not in that, no. I beg your pardon. In this country, no. I was involved in the one in Australia.
Thank you. Have you ever developed a cavity barrier strategy for a high-rise residential property in practice?
No, I have not.
Has your practice?
Our practice is 1,500 people globally.
Right.
Somewhere they will have done it.
Right.
Many times, I expect.
Can I then turn to a different topic? Where a value engineering exercise, properly so called, takes place and produces a new product to be specified and installed on a building in place of a product previously specified, would you expect the reasonably competent architect to maintain a clear documentary record of the change?
Yes.
And what format would that clear documentary record take?
When, what was before, when in terms of what stage it's at, what was before, what is being proposed instead, and any information to make absolutely clear the status of the before and the after, which is drawings and specification notes.
Would you expect the reasonably competent architect to set up or agree with the design and build contractor with whom he was now working a change control structure or system?
Yes.
And
Well, I would expect it to be set up, whether it was initiated from the design build contractor or the architect. I would actually expect the design build contractor to set it up, but if in the absence of that, the architect should call for it.
right. And would you expect the record, whether it's a system of change control or any other sort of system, would you expect that record to contain an investigation of how the product maintains the performance and functionality of the previously specified product?
And compliance, yes.
And compliance,
Yes.
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 Thank you very much. Yes. Well, Mr. Hyet, thank you. I've got no further questions for you, and it only remains for me to express the gratitude of both my team and of myself for your assistance, both over the last 3 days and in constructing the model and in your report work generally. So thank you very much. Those are all the questions I have for you.
Yes, well, I think I should extend the gratitude of the inquiry as a whole, and certainly of the panel, for all the work that's gone into producing your report, that splendid model, which was very illuminating, and the time you've taken to come here and give your evidence. And we're very, very grateful indeed. So thank you very much.
Thank you. Our entire industry, sir, and all the professions within it, and my own included, I think there has to be a lot of very careful contemplation from here on.
Right. Well, thank you for your part in what we're doing.
Thank you very much.
Thank you, Mr. Hyet.
Thank you. Well, Mr. Millett, that, I think, concludes the proceedings in Module 1, is that right?
Mr. Chairman, I'm glad to say that it concludes all the evidence in Module 1, the factual and expert evidence. There are, of course, closing submissions or statements to be made for Module 1 at the end of Module 3, but for the time being, that is the end of Module 1. I'm delighted to be able to tell you that. and others who are listening to this. And it therefore follows that Module 2 will begin without pause for breath tomorrow morning.
So we'll call a halt there for today, but we will meet again tomorrow morning at 10 o'clock when we will embark upon Module 2.
Thank you very much.
Good. Thank you very much. 10 o'clock tomorrow, please.